We can now start and listen to Professor Richard Susskind.
Thank you very much for that kind introduction. Can I check that people can hear me? Can you wave your hands in the audience if you can hear me? Raise your hands. Excellent. Thank you very much, Chief Justice, for that introduction and for raising so many of the issues I will also cover. I should say, first of all, what an honor and a privilege it is to be addressing your group today. And I want to talk about justice in a digital age. This has been what I have spent my whole life thinking about for 40 years since I was a legal undergraduate in Glasgow University. I've been wondering how technology could improve access to justice. And in the next 45 minutes or so, I want to give you some of my own thinking that's developed over these 4 decades. And this is thinking that's been developed closely with the judges of England and Wales, whom I've advised over the years. I want to start with the problem that I think we face and that technology can help solve. I then want to suggest to you the mindset you should have in thinking about the future. Then I'll reflect on what has happened during the pandemic and how that has, to some extent, accelerated our thinking and practice in the use of technology. I'll say a little bit about technology itself. One doesn't need to be a technologist to understand its potential, but I will highlight a few of its key aspects. Then I want to suggest to you what I think are the key characteristics, 5 of them, of the future of the digital system within law and justice. And I want to close by reflecting on the concept of justice, because this is close to my heart, and to suggest to you that we can align our thinking about what is just with our thinking about the use of technology. Before I launch in, though, I do want to stress that my own focus is on the long term. I appreciate that within the audience, you represent and are from countries with various levels of internet access and technology take-up. But the changes I anticipate to justice systems take about a decade to introduce. No country in the world has yet introduced these. Some are moving more quickly than others. But the 20s, I believe, in Africa, and I say this as an internet professor, I'm a law professor as well as an internet professor, but all the research suggests during this decade, within Africa, technology will burgeon. Internet access will increase and improve. More and more people, not just for legal purposes, but for medicine, for public administration, for education, will use this technology. So if we anticipate in the coming decade this infrastructure coming in place, the question is, how can you start planning now for the introduction of the technologies in law and in justice and courts in the coming decade? You even, I think, have the opportunity to leapfrog some jurisdictions that I believe are moving perhaps a little quickly. Now is the time to start planning. But let's start with the problem that I mentioned. And in fact, there are 3. The most recent problem, of course, from the pandemic is that around the world, many hearing rooms have closed. This has also meant, and this is the second problem, that large backlogs have built up in court systems around the world. But there's a third and more profound problem, and it was hinted at in the Chief Justice's introduction, that even in legal systems that we dare to call the most advanced, if you take civil disputes as an illustration, to resolve these disputes in most jurisdictions costs too much, takes too long. The process is often excessively combative. It's also not understandable unless you're a lawyer. And increasingly, the way we practice law and administer justice, certainly for younger people, feels out of step in a digital society. And these, again, as the introduction stressed, are not problems in any sense unique to Africa. These are global problems. It's the global access to justice problem. In some court systems, we're seeing staggering backlogs. In Brazil, for example, there's a backlog of 80 million cases. as yet not decided by the courts. In India, that backlog is 30 million cases. I think the most worrying statistic of all comes from the OECD, whose research suggests that only 46% of human beings live under the protection of the law. Less than half of the people in our world have realistic access to lawyers and courts. They have no reasonable ways of understanding and enforcing their entitlements. That's the backdrop. That seems to me the problem we're here to solve. As for the mindset you should have, the question I've been asking since the 90s is this: is court a service or a place? Do we always need physically to congregate together to sort out our legal differences? Or in an increasingly digital society, might we find different, quicker, cheaper, more convenient ways, virtually, of solving legal disputes? And I stress here, not all legal disputes, but at least some legal disputes. So that's my first mindset challenge. Is court a service or a place? But let me also tell you my favorite anecdote in the world of management. And it's a story about Black & Decker, one of the leading manufacturers of power tools, who apparently, when they recruit new executives, take them off on a course, sit them in a room, much like the room you're sitting in, and put up a slide of a gleaming power drill. And they say to the assembled new executives, "This is what we sell, isn't it?" And they all, of course, agree. That's what we do. We're the leading manufacturers of power tools. Well, the trainers with some satisfaction say that's not what we sell, because that's not really what our customers want. This, they say with a flourish, is what our customers want. And up comes a picture of a hole neatly drilled in a piece of wood. They say that's what our customers want, and it's your job to find ever more imaginative, competitive, creative ways of giving our customers what they want. And we have to be of the same mindset in thinking about the future of courts. It's not simply about, if I can use the metaphor, producing a lighter, cheaper, quicker power drill. We have to think more fundamentally. What is the hole in the wall? What is the problem we exist to solve? And in a digital society, when frankly we're not solving that problem satisfactorily, might there be different ways of resolving legal disputes? And I know this is a huge challenge, and I plead also for an open mind. But I underscore again the reality that today in our court system, we are not offering sufficient access. Another mindset issue relates to technology. I draw a distinction between automation and innovation, and this is vital. Automation is what most people think of when they think of technology. They think of taking some kind of process or task, systematizing it, computerizing it, streamlining it, optimizing it, but not fundamentally changing it. The first 60 years of court technology has been about automation, grafting technology onto our old ways of working, systematizing our traditions. Often, I'm afraid, that delivers, if you'll forgive me, mess for less. It doesn't underlie, or rather, it doesn't address our fundamental problems. So instead, I ask you to think beyond automation to innovation, by which I mean using technology not to support or enhance our old ways of working, but fundamentally to change our old ways of working, to disrupt, to replace, to displace, to allow us to deliver better access to justice in a digital society. I don't think you should be assembling in your room to discuss automation, or not at least automation. You have to go beyond computerizing what you already do if you want to deliver better access. So what of COVID-19? Well, I was heavily involved since March 2020 in the design of a system called Remote Courts Worldwide, www.remotecourts.org. And in that resource, on that website, you can find news of how jurisdictions around the world adapted to COVID, how they set up remote courts, as we call them. And 168 countries, certainly in our system, 168 countries moved at least in part from physical courtrooms to some kind of remote hearing. And there were three kinds of remote hearing: by audio, essentially telephone conference call; by video conference using the kind of technology we use today; and some paper hearings. In fact, not a hearing at all, but arguments and evidence submitted in electronic form without oral evidence or a physical hearing. But the technology that has, I think, been most successful has been the video hearing. And I want to make 6 observations about the video hearing. The first is that they've worked rather better than most lawyers and judges would have expected. If you had suggested video hearings in early 2020, most lawyers and judges would have said it's not possible and certainly not desirable. But in practice, for many cases, they've worked rather well. Secondly, we find that judges and lawyers actually can adapt quickly. It's often said, and I've often said, that lawyers and judges are conservative, resistant to change. But that doesn't mean if the platform is burning, if the iceberg is melting, that judges and lawyers cannot adapt. The response to COVID has shown that judges and lawyers can indeed embrace technology. So the third observation I would make is that because of the use of these systems and services online, many legal minds have been open to new ways of working. Some legal minds, in fact, have been changed. I also acknowledge that an absence of technology in some jurisdictions and poor technology in others has been a problem. You cannot satisfactorily offer video hearings unless the enabling technology functions. But one thing to think about, the technologies you see today are the worst they're ever going to be from now on. Our technologies are getting better and better. And as I say, in Africa, increasing investment and deployment of these technologies. We cannot judge the acceptability of COVID technologies for the future simply by looking at today's shortcomings. We have to anticipate and indeed urge improvement in technologies. I would say fifthly as well, that COVID has had an unfortunate polarizing effect in the legal world. Some lawyers and judges say we should never go back. We should use video hearings more extensively. This is the future. While others are saying we cannot wait to go back. As soon as we can, we should dismiss all this technological nonsense and return to proper legal and court work. I sit somewhere in between. I think the future will be a blend of traditional hearing and of video hearing and I'll explain this, online courts. I don't think we should be dogmatic and insist on one way or the other. I think we should find what suits our legal system and what suits different kinds of cases. But I underpin again my major point that if we continue as we've always been, offering physical court hearings, we will not crack the access to justice problem. I also want to say that COVID-19 has accelerated some uses of technology, but it's actually decelerated others. Using my earlier distinction, and this is the subject of a different lecture, in my view, COVID has accelerated automation, but decelerated innovation. What we've essentially done is we have dropped conventional hearings into Zoom or Teams or some kind of video conference. We haven't much changed the underlying participants, for example, still judges, still lawyers, still similar rules and similar processes. I don't think the future has yet arrived. I don't think home working is a full transformation of the court system. I don't think dropping hearings into Zoom is a shift in paradigm, as commentators want to suggest. We are, Chief Justices, Deputy Justices, ladies and gentlemen, we're still at the foothills of change. We've seen a glimpse of how we might, in one way, offer different forms of court service. but there's much more to say. There's much more to do. And in fact, I think to a large extent, in light of the COVID experiment, it's been like a huge pilot, an unscheduled pilot. We should go back to the drawing board and think about the future. And that is what I've tried to do in my work, and most recently in a book called Online Courts and the Future of Justice. And I'm hoping some of you will have been given the latest version of that book. What I'll try to do today is summarize 400 pages in about 10 minutes, but just to give you a sense and a flavor of the arguments. But I stress the 400 pages because I want to say that I've given serious and deep thought to how it is we might improve access to justice. Some lawyers and judges view me as the enemy. They say that my views on technology are a threat. Quite the contrary. My values align, I suspect, entirely with yours. I just want to find ways of plugging the justice gap. And I say technology in a digital society can play an absolutely vital role here. Here's a couple of things to think about technology. The first is that our systems are becoming increasingly capable. Hardly a day passes that we don't hear news of some new development, technology, app or system or breakthrough. We live in remarkably changing times, a time of greater technological advance than humanity has ever witnessed. It's happening in our watch, and for us to think that it doesn't apply to the most information-intensive, to the most document-intensive industry of all, the law, is simply misguided. And here's another thought. There's no finishing line. No one in Silicon Valley or China or South Korea is dusting their hands off and saying, job done. That's technology finished. We can move on to another project. Or let's plateau for a while. Not at all. The pace of change is actually accelerating. It is the case now that in our world, and this figure changes by the month, 59% of people have access to the internet. I mentioned earlier that 46% of people have access to justice. Isn't it remarkable that more people today already have access to the internet than have access to justice? And that figure I stress of internet access is growing as the days go by. So how can we use the internet technology as a platform to offer greater reach, to help more people understand and enforce their entitlements? Well, I believe we'll see five major trends in the coming decade in the use of digital technology in the court system. I'll tell you what they are, and then I'll dip down into a little detail on each. The first is what I call asynchronous online judging, a term to be explained. The second is what I call extended court services. The third is front ends. I'll explain all of this. Fourthly, artificial intelligence. And fifthly, what I call dispute avoidance. So asynchronous hearings. Communication is synchronous when the parties communicating need to be available at the same time. A physical meeting, a telephone call, a video meeting. The people communicating have to be available at the same time. We call this synchronous. Asynchronous communication is when we manage to communicate with one another without being available at the same time. A text message, an email, a WhatsApp. These powerful methods of communicating that dominate so much communication in our world don't require people to be available at the same time. And I recommend, and this is what my book's about, the idea of an asynchronous judicial process. Not for all cases, but my recommendation is for everyday low-value disputes, civil disputes, family disputes, administrative disputes, we can use this technology, this method, I call it online judging. And it's not unlike the paper hearing I mentioned earlier. The idea is simple and not new, that the parties submit their arguments and evidence in papers, but it's electronic form, to the judge. There's some kind of online discussion and debate as though it was an exchange of emails online, and the judge delivers his or her decision electronically. Certainly in England and Wales, but in many jurisdictions, we've been deciding cases on the papers alone for many years. In a digital world, we can make this more systematic and effective. It's far more convenient for people. They don't need to take a day off work. It's far quicker. It's less costly. There are illustrations of my book how it can work. I stress, not for all cases, but it's a way of offering access where none today exists. That's online judging. But on its own, it won't be enough to increase access to justice without my second prediction, and that is extended court services. Traditionally, in a print-based society, the function of the court service, above all, is to deliver independent, binding decisions for parties. I believe we should think about and introduce a secondary function. In a digital society where access to justice is prejudice, I argue that our court should provide more than the primary function of binding decisions. I argue for extended court services. I want parties without legal help to be able to go online and find out more about their legal position, to understand their rights or entitlements, to understand the options available to them. I want these extended court services to help these parties without lawyers to help structure and organize their legal arguments, to help organize their evidence. I know you'll be thinking this isn't possible. I have spent 40 years showing this is possible. My doctorate at Oxford was on this subject. We have been able to develop and deliver these systems for years. They're not perfect, but they are so better than the nothing at all that most people around our world receive by way of legal guidance. I also want online the possibility of systems that can allow the parties to resolve the disputes themselves through some kind of online negotiation or perhaps mediation. Alternative dispute resolution, not as a private sector alternative, but baked into tomorrow's court system as an electronic service too. This is what I call the electronic court service. And in my book, I provide an architecture for this. It's not a pipe dream. Have a look at the Civil Resolution Tribunal in British Columbia. It uses precisely these techniques of online judging and of extended court services. I admit, for low-value disputes, but these are often the disputes that dominate the work of our system. And these are often the disputes that people just don't manage to bring to the system. Have a look at the level of user satisfaction with the Civil Resolution Tribunal and compare that to the levels of satisfaction with conventional court systems. On eBay every year, eBay, the trading system, more than 60 million people have disputes. Almost none of them are sorted out by lawyers and courts. They're sorted out by online dispute resolution. The 20s is the decade during which this technology will come to the rescue of our justice system, upholding the rule of law, enhancing access to justice, building on this phenomenal infrastructure, the internet infrastructure that we're seeing burgeoning around the world. The third development, though, acknowledges what many of you will be thinking. If we cannot provide the primary function satisfactorily, how can we afford extended court services? So my answer to that, first articulated in an article in the online journal of Harvard called The Practice, and now in the paperback preface to my book, is the idea of front ends. And this is the idea of a public-private partnership. It might not be a commercial organization, it could be a charity or an academic organization, but bringing the extended court facilities that I'm talking about, tools to help non-lawyers understand their legal position, to help them prepare for court, to help them resolve their disputes, that is provided as a preliminary online service connected to the court, but not delivered by the court. And the Master of the Rolls, our top civil judge in England and Wales, has suggested that these could be accredited providers, given a blue tick, as it were. These systems could be connected to the court system in the event that disputes are not resolved by them, technically to transfer documents, and perhaps, and this is what many of us are thinking through, an accelerated way of enforcing decisions by non-court bodies. But the idea of the front end is to bring the bigger legal community, the charitable community, others into the orbit, as it were, of the court system, almost like satellites around the court system. These front ends that to some extent have the teeth of the court system, the shadow of the coercive powers of the state are there, but it's quicker, it's cheaper, it's more convenient. This is another way, the front end, that we can increase access to justice. What about artificial intelligence? Well, as I say, this has been my life's work in law. And I can speak for months on this subject. There are different forms of artificial intelligence. But for the purposes of our discussion today, I think you should think that there are three ways that artificial intelligence in the coming decade will affect the work of the courts. And this maps onto my architecture for the online court. The first way is by providing online guidance. My idea of the extended court, or of the front end, is that court users can understand their rights and entitlements online. For this purpose, we need diagnostic expert systems. A first generation of AI, my own specialty, these are systems that can identify and help people understand their legal positions. It can be done technically. I've written books on this, 4 books on this subject. Do not assume, I'm afraid, and I'm going to be challenging here, because you do not know much about the technology, that it's not possible. I put my career on this. We can develop these systems. Think of them perhaps as very complex decision trees or flow charts. The technology is proven. It's just very, very sparsely used across the legal world. We are, I'm afraid, a conservative old bunch. So online guidance will help people understand and help them prepare for court. There's a second and more advanced function, also part of the extended court system. You may know there now that there are systems that can predict the outcome of court decisions, often as well as, if not more accurately, than human lawyers. And these systems, again, are getting better and better. I've no doubt during the 20s, these systems will be way more effective at predicting court outcomes than lawyers. Again, I ask you just to accept what I'm saying. The technology is there, even though I accept you won't be familiar with machine learning and deep learning and so forth. There are tens of thousands of scientists working on this around the world for other areas, and some now working in law. One of the things clients often ask their lawyers is, what's our likelihood of winning? What's our prospect for success? And that informs their decision as to whether or not to proceed. I believe these predictive systems should be baked into the extended court services to help people understand the likelihood and therefore the sense of them progressing. The third role of artificial intelligence is far more challenging. And again, I've thought for decades about this. It's whether or not, prepare yourself for this, whether or not court determinations might ever be made by a machine. Now, let's be very clear. There is no system now, and there's no technological prospect in the realistic future of a system that can reason, that can weigh judgments, that can function as you do as outstanding judges. There is no system today or in the reasonable future, there is no prospect of a system that can provide decisions with reasons, which fundamentally is what most judges do. But there is another way of looking at this. Let's go back to this idea of prediction of outcomes of cases. And I'm not recommending this, but in the spirit of the introduction, I want to essentially widen our thinking. And the idea I have in mind here is predictions as determinations. So let me explain this. Remember, I just mentioned the technologies that can predict the outcome of cases very accurately. So let's go to Brazil, for example. In Brazil, we could say to parties, many of whom who are in the 80 million people queue, your case will never be decided by judges and lawyers. You will not live long enough for that to happen. But we have developed a system that can predict the likely outcome of your case. And all of this is based on all the past decisions, of the court. You could say to the parties, would you accept the output of that system as a binding determination of our court? If, for example, the degree of confidence from the system is, say, 95% or higher. I can explain that technology. My idea here is that the prediction can become a form of binding determination with the consent of the parties. Now, you may say, my goodness, this is nowhere near as good as a judge deciding a case. But remember, first of all, it's based on judges' past decisions. And remember, too, that my argument is not that it's better, but it's a way of providing access where today we otherwise have none. And there are big debates to be had here about what's known as the opaqueness, the opacity of machine learning systems, because these systems do not provide reasons with their decisions. There's also the worry of bias. But if there is bias in the past data of judicial decisions, we're doing no more there than holding up a mirror to the judicial system. The fifth development I think we'll see far more of is what I call dispute avoidance. Most ordinary people want a fence at the top of the cliff rather than an ambulance at the bottom. They don't want a dispute resolved well by lawyers and judges. They want to avoid disputes in the first place. And there are a whole variety of techniques emerging under the heading of legal risk management, for example, that will help people avoid disputes in the first place and contain disputes when they do arise. So that's the future I see, a future where we have online judging, where we extend our court services, where we have front ends, where you use artificial intelligence, and where we have systems to help people avoid disputes in the first place. Let me say a few words by way of conclusion about justice. Just judges without courtrooms, justice without lawyers. Many people regard this as seditious. They regard me, as I say, as the enemy. But what's very interesting is that critics and supporters of the idea of online courts both use the language of justice. Very often, judges will say to me, you cannot have a just hearing online, whereas others will say to me, it's unjust that we live in a society where so few people can understand and enforce their rights. And this has led me, and I used to teach jurisprudence, legal philosophy in Oxford, it's led me to think a little bit about what we want of a justice system. And I argue we don't just want justice full stop. We want 7 different conceptions of justice, whether or not they're delivered in a physical courtroom or online or virtually or however. We want substantive justice. That's to say fair decisions. We want procedural justice. That's to say fair process. We want open justice. That is to say transparency. We want distributive justice. That is to say accessibility to all. We want proportionate justice so that the cost and effort and upset of proceedings is consistent with the nature and value of the dispute. We want enforceable justice. That's to say that determinations are backed by the state. And we want sustainable justice. That's to say a system, whether physical or electronic, that is sufficiently resourced. And my argument is that in thinking about the future of courts and comparing online courts and traditional courts, we should reflect on each aspect. And my own research suggests that in some cases, but not all, an online court can outperform a traditional court in ticking more boxes in my justice test, that 7-pronged test. Now, I know there's all sorts of objections to online courts. Some people say there are economy class courts. A quarter of my book is devoted to refuting, or at least addressing, because I can't meet all the objections. And some people say that online courts are economy class courts. But I believe many younger people will think a system that is quicker, cheaper, more proportionate, easier to use, that's the first class system. People say they're not transparent. I think the COVID experience has suggested that in many ways, given the reach of the internet, an internet-based system can be more transparent. Many people say that an online court cannot play host to a fair trial. In Europe, they refer to Article 6 and they say a fair trial has to be a public hearing. I argue we are rethinking what our notion of public is. Indeed, often when we say we will make something public, we precisely mean we'll make it available on the internet. And I argue at length that we can maintain, not in all cases, but in many, the fairness of our trials. vital for you, I appreciate. Many people say that what I'm proposing is digital exclusion, because in many countries and in many homes, people can't afford access to the internet. I say again, though, two things. One, we are increasing access to the internet every day. And we're planning here not for 2021, but for 2030. You're engaged in long-term strategic planning. This is our legacy. We're accelerating the use of these technologies. And secondly, I say, even if we don't reach everyone, we'll reach more people than our physical courts do. Many people often say that public sector technology projects fail, and that is true, but that's not a reason not to try. That's a reason to do these projects well. The key concern, if your issue is really about access to justice, is not whether online courts or virtual courts will replace traditional courts or which are the better. The key question is whether the kinds of things I'm suggesting today, I believe, can take on some of the work that our traditional courts do not or cannot. And for those who argue from the point of view of justice, I believe often in the name of justice, many critics are missing the chance to reduce manifest injustice. I can conclude with a quotation from a man called Alan Kay, who's a Silicon Valley computer scientist. He once said the best way to predict the future is to invent it. And I think that's a useful lesson for the group today. In the end, all I am is a commentator on all of this, and I try to be a catalyst. But you are senior chief justices. You have a vital role in the development of your legal system. So you've kindly asked me here today, here virtually today, to predict the future. But I want to put it back at you. I want to ask, what future are you going to invent for your justice systems in a digital society? Thank you very much.